Hi, everybody. Looks like we are live on all the channels. Hi, everyone. It's Carol Williams with Williams Immigration. I'm back for a Saturday early evening live. I am Carol Williams. I am managing attorney of a boutique immigration law firm where we help businesses and business owners who are looking to hire individuals that are not U.S. citizens. So they're looking for that international hire. They have found that person, then they need an immigration attorney like myself to make sure that they have the right visa in place. That is what I do for my business owners. I also help individual folks who are looking to self-sponsor their green cards. So we do those applications as well. EB1s and EB2 national interest waivers. And I also help family members apply or sponsor their family members for green cards. So that's in my practice, that usually looks like a US citizen or a green card holder who wants to sponsor their spouse, their parent, their fiance, or their minor children. Remember, minor in the US immigration system is under 21 years of age and unmarried. So if you are married and you are 20, you are no longer considered a minor or a dependent in the U.S. immigration system. So just keep that in mind. So today, I want to, as always, get to your questions if you have any. So feel free to drop those in the comment section. But today I wanted to talk to y'all about the EB1 category for green card, extraordinary ability subcategory. And it is a category where you can, as an individual employee, you can self-sponsor, or your employer can sponsor your EB1 extraordinary ability. So EB1 extraordinary ability essentially you must show that you are really, really good at what you do, that you have extraordinary ability and with what you do. You can be in any kind of field. There are no specific fields that you have to be in. So you can be in science, arts, education, business. You can be an athlete, but you do have to show that you are extraordinary ability and at the top of your field. So they lay out 10 criteria for us, and we have to meet only 3 of them, y'all. What I like about extraordinary ability is that it lays it out for us. It is crystal clear. There, we have to meet the 3 of the 10. So I'm going to just kind of lay out these 10 for you so that you understand that, and then we will jump into some questions if y'all have any. And the 10 criteria are you can have awards that are national or internationally recognized. You're a recipient of that award. You have memberships and associations that demand outstanding achievement to become a member. So not an organization where you just pay your money and you're in. Like, you've got to have done something in order to be a member. You have published material about you in professional or major trade publications or other major media within your field. So it could be that your field, the major media, could be online publications. Doesn't just have to be a print publication. So always want to keep that in mind. This is one of the things I love about this. Again, it gives us criteria, but it's a little flexible within that criteria, right? Because we've got to look at and remember, what works for one industry may not work for another industry. Evidence, and so that last criteria is that people in your industry are talking about you. They know who you are, even though they may not know you. The next one is evidence that you've been asked to judge the work of others, either individually or on a panel. So if you are judging someone else's PhD project, if you are, being brought in to wholesale look at the way that someone is doing business, that kind of thing. if you are looking at how other people do work, if they have invited you in to see how they are doing work and to provide critique, that might work, right? Evidence that your original contributions play a major or a significant role in the field. So you want to keep that in mind. What are you doing to move the needle in your particular field, in your particular industry, in your particular slice of this life? That is not necessarily the same as what are you doing to move the needle with your current employer. A lot of people are doing really great things at their current employer, but that's not you moving the needle in your industry. So you want to keep that in mind. What have you written? Do you have any authorship or scholarly articles that you have written? Where are they written? What is the name of the publication? What's the circulation amount of the publication? Like, how many people get this publication? Because if it's just you and your parents, that's not going to work, right? But if we have a significant publication that goes out to a ton of people, that is good. That's always good. Evidence that your work has been displayed in an exhibit if you are an artist. That is something that is helpful, because remember, this category is not just about an athlete or an artist. It is an athlete. They're artists. They are business folks. They are folks in the medical profession. So it's all over the map, the types of careers and jobs that people have when they are applying for EB-1 Extraordinary Ability Green Card. Evidence that you have performed in a leading or critical role in distinguished organizations. So it is not just important that you have been in this great organization. What is this? Why is this organization great? Why should the Immigration Service care about this particular type of organization or this particular organization? So we want to talk about not only your role in the organization, but why the organization is such a big deal. Okay. And then that you're getting a higher salary, significantly higher salary than everybody else in the field or than others in the field, right? So you want to, we certainly have ways to pull salary data on our end. That is one of the, that is one of the things that we always look at, because we can pull salary data. And if you are in the performing arts, evidence of your commercial success, right? Do people know that you're out there? Do they know what you're doing? So those are the criteria for EB-1 Extraordinary Ability Green Card, which you can self-sponsor. But you don't have to self-sponsor it. Your current employer or your future employer could absolutely, sorry, I have an itch in my leg. Your current employer can certainly sponsor that. Your future employer can sponsor you. You can apply for extraordinary ability if you are inside the US or outside of the US. So you do have some flexibility there. And it is a fun category. I learn something every single time I do an extraordinary ability application for my clients, because they are doing such amazing things and their professions are all over the map. So it's super, super fun. Let me get to some of your questions. And honestly, just kind of the length of time I spend on today will depend on how many questions we got. Let me see. What do I got over here? Okay. Let's see here. What do we got? If y'all have been watching me, I'm a slow scroller. Okay. Okay. So someone has asked for timelines. I don't generally give timelines because I have to look up timelines. So processing times, I will say this for those of you that are currently watching and who may watch the replay. Processing times depend on the type of application. One, the type of application. Two, which office has that application and is looking at that application. So when my clients ask me for the processing times, and when my team provides the processing times, we look at very specific processing times. So my question during a live will always be, I generally don't know what the processing times are because they would require me to look them up. And these lives are meant to be educational and to, talk about general topics. So let me take the first part of your question. The easiest and quickest procedure for I think you mean permanent resident, to get the spouse into the US. I don't know the fees off the top of my head. I also have to look up the fees too. I have not memorized the fees. I do with all sorts of applications on a daily basis. I haven't memorized the fees. So let's see here. Permanent resident. Let me go through this. I think this will be helpful for y'all. Permanent residents can sponsor their spouses, their children, and their unmarried sons and daughters. So an unmarried son or daughter, that means unmarried child over the age of 21. That's what that means. Permanent residents. Really depends on, so the Immigration Service they're only allowed by law to approve a certain number of green cards every single year. Because permanent residents sponsoring their spouses, they are F2A, they are second preference. So they are not first preference, they are not immediate relatives. So there is going to be, for sure, a wait time. How long of a wait time? I don't know. It depends on where your spouse is from. If y'all have filed anything, if you haven't filed something, it will all really depend. That is something I talk in depth with when I do a consultation with folks, so that they understand what their specific time frame is, where they can look at it themselves. So that's really like the easiest and quickest way. That's a consultation question. And you can do that. I'm happy to do that with you. Just click the link in my bio and you can get your consultation scheduled. That is how all folks start to work with me. They start to work with me by scheduling a consultation. I look over your facts, what kind of case we're working with. Is it even something that I handle in my firm? And then we go from there. So I gather a lot of facts to figure out whether or not I can help you and how I can help you. Y'all, I don't know why I don't put my glasses on. I feel like I need someone like right next to me reminding me. Okay, I got an RFE for a 485. By the time I sent the medical, I will be 2 years married. Will I get a 10-year green card? So if your green card, if a family-based green card if a marriage-based green card, I should say, is approved and the couple has been married for more than 2 years, it will be a 10-year green card. If the marriage has been valid for less than 2 years, it will be a conditional permanent residence. So at the end of that conditional permanent residence, close to the end of that 2 years, 90 days ahead of time, you're going to need to file to remove the conditions. I tell people to think of it as moving from a temporary permanent residence to a true permanent residence. So kind of temporary to perm. In their words, conditional permanent residence to just regular plain Jane permanent residence. But if you have been married for over 2 years, when your green card gets approved, you should get a 10-year card and you should then not have to remove the conditions. So, but you can also ask, when you go to your interview, you can also ask them that if you get an interview. Let's see here. What else do we have? Hold on, I think I missed some. Let me scroll back up. My girlfriend applied for a student visa. Can I apply for a K-1 visa for her? I mean, technically you can. Whether that is advisable is a completely different story. And that I don't know. That is really a consultation question. That is a strategy question. Not sure if the student visa got approved, if it didn't get approved. That's really that's a hardcore strategy question, which I can't tell you should or should not do that. So that I don't know, but you're welcome to schedule a consultation and we can talk about that. I-24 approval times, I do not know. I look them up I look up approval times and processing times every single time my clients ask me. That is something I would have to look up for you. But y'all, you know that you can go to the USCIS website. If you go to their homepage, scroll down, you can look up processing times. You can absolutely look up processing times. They are right there for you. Let's see. Well, thank you for the badge, Christian. I appreciate that. And the rose. Let's see here. Does USCIS give a receipt after filing of an EB3? Absolutely. Once you're, I don't know where you are in the EB3 process, but in general, the EB3 process is filing with the Department of Labor. You get, or I, as the attorney, get an email saying that the application has been filed, and that's a labor certification, or otherwise known as PERM. I get an email telling me that has been filed. After that, I get the approval. Once then we file the I-140, I get a receipt notice telling me that has been filed. And then if you are at the adjustment of status phase, then I get receipt notices for the adjustment of status application. My firm always files work authorization and travel permission, and we also get receipt notices for those. So yes, USCIS absolutely does give, they do send out receipt notices, and DOL sends us an email. Now, if you filed your EB3 using premium processing, when I do that, I get an email from the Immigration Service because it's quicker. I also get a paper notice following in the mail, but I do get an email that I then let my clients know, so that we're not all, so they're not kind of waiting on the mail to come. So I hope that was helpful. Let's see here. I'm on a visitor visa. My husband is a green card holder. Can I apply for adjustment of status? I mean, that's really a consultation question. A lot of times my answer is going to be yes, you can fill out the paperwork and send it in. The better question is it advisable, right? Is it advisable? I don't know in your particular instance. I don't know how long you've been here. I don't know what country you're from. I don't, there's a lot I don't know. I don't know what you've been doing since you got here. Have you violated your status since you've been here? I'm not suggesting that you have. Don't get offended. I'm just saying these are things that I ask people during consultations. These are questions and information that I elicit from them because it helps me create a strategy for them. It helps me essentially answer that question and say to you at the end of the consultation, yes, I think you can apply for your green card, or there's a few things I think we should do before you get sponsored for your green card, right? So, can a green card holder sponsor their spouse? Yes. Is it always advisable? Sometimes yes, sometimes no, right? So those are things that we would need to dig into during a consultation. How long an interview asylum for India? I don't know. I don't handle any asylum work in my firm. You'd have to talk to somebody who handles asylum all day, every day, and that's just not what I do in my firm. That is a piece of immigration that I don't do. Does USCIS check your divorce decree if you are married in the U.S. and divorced in the U.S.? Depending on the application type, the marriage certificate and divorce decree must be submitted. So if you're applying for a green card, all divorce decrees must be provided to the Immigration Service. So yes, they will check your divorce decree. If a spouse is applying for your green card, the Immigration Service wants to know that there is only one spouse. Sometimes there has been a hiccup or confusion with documents, sometimes in the US versus documents and things that happened outside in the US in the home country. And so it may be that that's one party was actually not eligible to get married in the US because they were already married overseas. That happens. So yes, the Immigration Service absolutely checks divorce decrees. So if that's a concern for you, that's something you want to parse through a little bit more, feel free to schedule a consultation. How long does it take to be called in for an oath ceremony after being approved for citizenship? It depends. I know no one likes that answer from lawyers, but it's really true. It depends on what office you're working with in the United States. All local offices handle naturalization cases. They are scheduled based on the workload of that office. It also depends on whether or not you are trying to change your name as part of your citizenship application. Name changes need to go through the federal court system. So the federal court system works with the Immigration Service to hold a special swearing in ceremony where you get your name change documents because they have been prepared at the federal court. And then a representative of the federal court will either come to the ceremony or the ceremony will actually be at, in the federal courthouse. So some folks get their oath the same day that they get their naturalization application approved. Some folks wait maybe 2 weeks. Some folks may wait 2 months. You could wait 6 months. It really depends on the workload of your local office and whether or not you are changing your name as part of that process. So, yeah, I don't know. My short answer to that is, or maybe not so short answer is it depends. Let's see here. I applied for 45U visa base, but now I'm married. How to file my spouse I-912 or I-929? I don't do any U visa work. So I don't know. I don't know the answer to your question. I don't even know where to tell you to go, except I would look for an attorney who handles U visas all day, every day. And there are those attorneys out there. That's just not me. I don't know. So I'm sorry, I can't help you. Let's see here. Someone is saying, thank you. You're welcome. A couple people have said, thank you. You're welcome. You're a little bit further down than your question. So I'm not quite sure what your question was, but that's okay. I'm glad I was helpful. How long does it take to get a work permit with a pending VAWA application? I don't know. I don't do any VAWA work, y'all. I have no idea. So I will not even hazard a guess what the answer to that is. What if I misplaced my work authorization card? How long does it take to replace it? So you've got to essentially go back to the Immigration Service and say, hey, I need a new card. So it is going to take basically as long as it's going to take for them to give you a new card. So you're going to have to file an application, tell them you lost it, have them issue you a new one. It will depend on what processing center is processing that card will depend on how long it takes. So I don't know. But that brings me to another thing that y'all should know. When you get these documents from the Immigration Service, put them in a safe place. Make copies of them. And this is not legal advice. This is just for your information conversation. It's educational, but truly, I tell this to my clients. And when I tell them this is not legal advice, right? But when you get your documents, whether it's when you file something, and let's say you're filing it without an attorney, make a copy of it. Make a copy of everything that you send in. Excuse me, not what you think you sent in. If you don't have a copy machine at home, you can scan it using your phone. You can go to a copy center, make a copy of what you send into the Immigration Service. I work with many clients who started the process on their own, felt overwhelmed midway through and started to work with me. They come to me, they schedule their consultation. Excuse me. I ask them for a copy of what they filed, and they do not have a copy of what they filed. That slows down my ability to help you. I get people that come to me, they have, an RFE from the Immigration Service, but they don't have a copy of what they filed. So all I have to go on is what's in the RFE, right? So the RFEs are time bound. We're given a certain amount of time. Sometimes we're given 12 weeks. Sometimes we're given 33 days to respond. If I have a notice of intent, if someone comes to me with a notice of intent tonight, it's 33 days that I have to respond. And if I don't have a copy of what you filed, that makes it a whole lot harder. And sometimes I just can't help you in such a short time frame, right? So always, always, always make a copy of what you send into the Immigration Service and make a copy of what you get back from them, and then scan it and just throw it into your cloud, throw it into your email as an attachment to yourself, because then you can pull that attachment down, give it to me when you're meeting me for a consultation, and I can say, oh, look, I have a copy of what you filed. But it's also super helpful if you lose something. If you lose your passport, or your passport gets stolen, or your house or your car gets broken into, like you've come from the post office, you stop at the grocery store, your car gets broken into, heaven forbid, and they take out, they take the paperwork, whatever. Scan as soon as you can, right? That is always very helpful. And it's also super helpful if you've lost something. If you have a scan of it, you can scan what you lost and include that in the application to get it replaced. Makes it so much easier on immigration side, right? So unfortunately, it is just going to take as long as it takes to get your work authorization card replaced. Hopefully you made a copy of it. I don't know. Hopefully you did, though. Someone's asking me what my specialties are. So here are the kinds of cases that I work on. I'm happy to tell you that. And I'll also tell you the cases that I don't work on, because that's also very helpful for you to know. I work with business owners and the managers and the in-house lawyers and the HR folks, human resources folks, when they are in the process of hiring or sponsoring one of their employees for a green card. They come to me and I help them do all the immigration paperwork, make sure that they have the right visa that gives them the best benefit, gives them work authorization, gives them the easiest path that we can give them for then the company to then sponsor their green card. So I work with companies. I also work with families. Typically in my particular practice, and every immigration lawyer's practice is a little bit different. We can say, oh, I work with families, or oh, I work with businesses, but some people really niche down into certain areas. But I also work with families. Usually in my practice, that looks like a U.S. citizen who is sponsoring or is trying to help a family member get a green card. Usually that family member is going to be usually that family member is going to be a spouse, a fiance, a parent, or a minor child. And remember, in the immigration world, in my world, minor child is unmarried under 21. If you are 20 and married, you are not a minor dependent in the immigration world. So those are the cases I work on a lot. So I work on EB1s, EB2s, EB3s, all green card preference categories. I do EB1 extraordinary abilities. I do EB2. I do EB1 multinational managers. I do EB2 national interest waivers. I do EB3s, PERM, I-140s, adjustment of status. On the non-immigrant sort of temporary side of things for employment, I help my clients with H-1Bs, which I call the workhorse of the employment-based immigration world. I get my clients entered into the H-1B lottery. If they're selected, we get the H-1B application filed. I work on TNs, which are our folks coming in from Canada and Mexico on professional visas. But because we have a treaty with Canada and Mexico, those applications tend to be quicker and they don't have to deal with the H-1B if their job fits in one of those categories. And there's a lot of categories. Maybe I'll talk about that one night. I do O1s, which are non-immigrant temporary extraordinary ability. I do R1s, which are religious workers. Do a whole bunch of stuff, y'all, on the non-immigrant side. But on the family-based green card side, U.S. citizen or permanent resident sponsoring a family member. That is what I work on. What I do not work on, because that is also important, I do not do VAWA cases. I don't do asylum cases. I don't do any deportation defense. So when folks call me about those or they ask me about those, I send them to, I give them a referral to other attorneys for those types of cases because I don't handle them. And so when you all are looking for an immigration attorney, remember, we don't all practice all areas of immigration. That's super important to know and to remember. And you want to ask if, this person can help you. And super important, believe them when they say they can't help you. I've had folks that liked me, really, really wanted me to work on their case with them. And I had to keep telling them, I'm sorry, it's just not a type of case that I handle or that I feel comfortable handling. Okay. So you want to keep that in mind too. So, but I appreciate that question. That was a very, very good question. Are there interviews for removal of conditions? Absolutely. Absolutely. The Immigration Service will absolutely call you in for an interview, just like they did the first go round. Now, currently, this is a temporary policy. We do not know how long this temporary policy, and it is 110% discretionary, y'all. Immigration Service doesn't have to do this for any single application. They are choosing to do this. If a marriage-based application, or if a green card application, a family-based green card application looks clean, meaning they have 0 in the background checks, the documents are great, they clearly show that individuals meet the requirements, doesn't look like this, that the relationship was entered into specifically just to get the green card, i.e. it doesn't look like a bogus or sham marriage. They are exercising their discretion. And again, keyword here, discretion. They do not have to do this. They're exercising their discretion and they are approving those applications without an interview. Not all cases are being approved without an interview. Okay. I always tell my clients this. I'm like, but my clients get prepared for an interview. I would rather have them prepared for an interview and then not called in for an interview. Right? If they're not going to interview you, you get an approval notice in the mail and your green card follows shortly thereafter. But yes, for a removal of condition, the normal operating procedure is that you will get an interview. Again, under this discretionary policy, they can opt not to interview you. But I always caution people to get ready for an interview, like get your mind right around having an interview. Processing times for citizenship, I have no idea. Processing times for citizenship depend on what local office has your file. And it depends on the workload in that local office. One local office could be taking 6 months. Another one could be taking a year. I do not know. You can absolutely go on the USCIS website though, and check case processing times, and they will tell you. If you have already filed and you have a receipt notice, which means you have a receipt number, you can check and see where they are on your specific application. And then you can check and just see what the general processing times are in the office that will specifically be processing your naturalization application. Let's see here. What else do we got? Hold on. Been 145 since AOS interview. I'm assuming maybe 145 days. And no decision on my 485, but I-130 has been approved. Is there something wrong? I have no idea. I have no idea if there's something wrong. I don't know. I don't know what you put in your application. I don't know the office that's processing. I don't know what they told you in your interview. 100, I don't know the processing times of that particular office. Could be 145 days is totally within their processing time. If it is, then there could be nothing wrong. If you are outside of their processing times, then yes, there might be something wrong. Typically, if there is an issue, the Immigration Service will send you a request for further evidence. They can also send you a notice of intent to deny, but they will kind of typically send you something. That is something I do for my clients. I kind of keep on track of their applications and see where they are. But I don't know. I don't know if 145 days for your specific office is too long, too short, right on track, or like super early. I don't know. Sometimes the immigration officer will tell you, what they think the time frame is. If you ask them, it may be accurate, it may not be. There are things that have to happen in a file after they do what they have to do in the file. Then it goes to other people, and they gotta kind of work on the file. So, I don't know. It says you got recommended for approval verbally too. That's great. But nothing is official until you get the approval notice in the mail. So, keep that in mind as well. Federal funding and medical assistance for permanent residents is okay in. I'm not quite sure what you mean. So I don't know what you mean by that. I'm not going to hazard a guess because I'm not quite sure. My son has his birth abroad certificate from me. Do I need to get him a naturalization certificate? This is interesting. I just had this conversation with a couple of colleagues, and we don't actually agree. So I'll tell you what I think about the naturalization certificate. I think a naturalization certificate is a good thing to have. The reason I think it is a good thing to have is because it is documentation from the agency, so from the government, acknowledging this individual is indeed a U.S. citizen, acknowledging that that agency has prepared something and sent it to you. That is always helpful when you are registering for college, registering for private school, going to, registering to vote, because we know if you are not a U.S. citizen, you cannot vote in the United States. If you are not a U.S. citizen, if you are not a U.S. citizen and you're voting, you should stop, because it will negatively impact your ability to become a U.S. citizen, right? Your naturalization certificate can help you get your driver's license. It helps you get your passport. So I think it is an important document to have so that you can show, if necessary, in many different situations, that this individual is a U.S. citizen. That is my take on it. Let me see here. Permanent resident receiving federal funding through medical clinic during financial hardship, citizenship issues. Will that affect your citizenship application? I don't know. I would have to know more about the services that were received and how it was determined that you were eligible to receive those services. So I don't know. But that said, I hope that you received the services that you needed and that you are doing okay. That is the most important thing. But if you want to schedule a consultation, we can certainly parse through that as well. And you can do that by clicking the link in the bio. What else do we have? Can you apply for the DV lottery while on a 2-year conditional green card? I guess my initial question would be, why would you want to do that? You already have a conditional green card. I don't we would have to talk. I don't understand why you would want to do that. Let me see here. All right, y'all, let me check over on, we are live on TikTok, but I'm also live in the Facebook group, the private Facebook group, the Facebook page, and the YouTube channel. So let me see if there's any questions over here. I don't see any. So this has been fun, y'all. I came in a little bit earlier today because it's the weekend. So I'm going to hop off, but you all know that you can find me online. You can find me here, obviously going live, but you can find me on TikTok. I'm on Instagram as well, YouTube, Facebook, all those platforms. My handle is at USA Visa Guru. You can also check out our website, which is clwimmigration.com. You are welcome to send us an email, info@clwimmigration.com. You can also call the office, 954-903-1337. You are welcome to drop comments and hit us up in the DMs. Please note, while I am an attorney, I am not your specific attorney, so I am not going to provide legal advice on your specific matter on the live, in a video, or via DM. If you want to work with us, that would be fabulous. That starts with a consultation. You can schedule that consultation by clicking the link in the bio and getting that scheduled for yourself at a day that works for you. Let me see here. Every single time, y'all are funny to me. Every single time I say I'm going to log off, I get like whoosh, a ton more questions. So let me see. You may have to come back tomorrow for these questions, but let me see here. My U.S. citizen wife filed I-130 for me and received September 2021 by USCIS Texas Processing Center. Okay, but that I don't know what your question is. Okay. Can someone who has U.S.-born daughter and deportation order from 23 years ago and never left? One, I don't quite understand your question, but two, I don't handle anything deportation related. That is not at all in my lane. Let's see here. And I don't know what those are from. Can they file and stay? I don't know what those are from. Okay, so that's all I got for you guys today. I don't see any more questions on any of the other platforms. So I will be live again tomorrow. We'll be talking about some other cool U.S. immigration stuff. This has been fun as always. I will chat with y'all tomorrow and have a good rest of your Saturday. And I will see you again tomorrow. Bye, y'all.